Welcome, I'm Jim Falk. The Constitution of the United States has long served as a model for emerging democracies around the world. It's admired for its endurance and its framework, which divides power among three co-equal branches of government, protects individual rights, and establishes a system of checks and balances. Tension among the branches is not a flaw, it's by design. Now, to help us understand the Supreme Court, its powers, as well as its boundaries, we turn to our go-to expert on the court, Stephen Vladek. Steve is a professor of law at the Georgetown University Law School and is a nationally recognized expert on the federal courts and the Supreme Court. He's also CNN Supreme Court analyst and author of the Shadow Docket. And if that's not enough, he also writes a Substack newsletter, One First, where he writes about the court and recent court decisions. Steve, great to have you with us.
Great to be with you, Jim. Thanks for having me.
So let's just start with a very basic question. What is the role of the Supreme Court?
It's a basic question, Jim. It's actually maybe a little more complicated than we might have remembered from our high school civics classes. So the Supreme Court actually plays two different but often overlapping roles in our constitutional system. In one sense, it is exactly what it says. It is a Supreme Court of Appeals. And so it is a court that is there to have the last word when lower courts disagree, when state courts disagree, and basically to ensure that our understanding of federal law, including the Constitution, is uniform. But Jim, it's also a constitutional court, meaning the Supreme Court is also there to provide interpretations of the US Constitution that, might lead the court to override statutes passed by popular majorities in Congress and signed by a popularly elected president. And so it really is this sort of dual hybrid role of providing finality, providing uniformity, and where necessary, providing supremacy on exactly what federal law means in a way that binds, whether formally or at least practically, just about everybody else.
One of the questions that always comes up at the Supreme Court is what ability does it have to enforce? A Gallup poll taken just last December showed that American confidence in the judicial system dropped to a record low of 35%. And then moreover, the degree that the respect for the court has declined was 24% in the last 4 years, which is more than practically any other country, or at least not a group that we want to be with, like Congo and Hong Kong under the mainland China. So what do we do about this?
One of the real problems when the court's confidence erodes, when the public loses faith, is that it creates more space for political actors, be they governors or presidents, to suggest that maybe we shouldn't follow the Supreme Court, to not have to fear the political consequences of not following the Supreme Court. Historically, presidents have followed the court not because they've agreed with the court, but because they just haven't had the political ability to disagree. So, President Eisenhower sending troops into Little Rock in 1957 to enforce Brown versus Board of Education. President Nixon turning over the last tranche of Watergate tapes, including the smoking gun tape that led to his demise. Those weren't things presidents wanted to do. They just faced such serious potential political ramifications that they had no choice. The problem we face, right, with a court who's losing that kind of credibility is the specter of a president who might, in a key confrontation, in a key moment, actually seriously consider not complying. And that's why, Jim, I think it's so important for the justices to do whatever they can to build back some of that lost faith, to find ways to build consensus in cases that might otherwise ideologically divide the justices and us, to find ways to avoid the appearance that the reason why the court is ruling one way versus the other is because of, whether they're ruling for Republicans or Democrats. Those kinds of moves, I think, are how the court can try to build back at least some of that faith. And, that's more important than perhaps ever before at this especially fraught moment in American history.
Do you think that's enough? And is there a consistency to it? Because we had this recent decision that came out, on Good Friday, where Justice Alito took a very strong dissent, but that dissent wasn't even released until the next day, which was abnormal, right?
It was abnormal. I mean, I think, Jim, not surprisingly, a lot of the cases arising out of the actions by President Trump during his second term have had abnormal procedural paths. And that's true whether you are in support of those policies or against those policies or have no view. These are unusual cases. I think one of the things, though, that we've seen already in these cases that the court has been deciding through what are called emergency applications, where
Yeah.
the Trump administration or other parties are asking the court to step in while the litigation is going forward. Jim, we're at least seeing the court trying to explain itself. And as you know, that's already an improvement over how the court had been dealing with these kinds of cases, these emergency applications, as recently as last year. So I think we're seeing some signs that at least a majority of the court, maybe not Justice Alito, maybe not Justice Thomas, are at least trying to help public appearances with regard to the accessibility of their rulings, with regard to the import of their rulings. I just think that it has to be more than just these individual high-profile examples. We need a broader movement that the justices have to be the leaders of, where more of what the Supreme Court does produces more headlines that are less about a 6-3 split between the Republican appointees and the Democratic appointees.
And really, that there is a very high percentage of cases that come before the court where there is all judges vote the same way, unanimity.
That's right. I mean, so if we just look at the October 2023 term, so the last full term of the court, the one that ended last October, the most common lineup was, as you say, all 9 justices being in the majority. Some of that, of course, is a reflection of the fact that the court is picking and choosing its own cases. And so, not even most of the cases that justices are taking, Jim, are these kinds of high profile, ideologically divided disputes. But I also think, that's something the justices can still further control. I mean, so one of the things we've seen in the last couple of years is, more and more cases coming to the Supreme Court from the federal courts in the Fifth Circuit. So that's Texas and Louisiana and Mississippi, where you've had a real push by conservative litigants to try to move the law to the right, for better or for worse. And, folks can disagree about whether it's for better or for worse. But that's put pressure on the justices in turn to take up really a disproportionate number of appeals from this one appeals court, in a context in which, Jim, a lot of these cases really do have very strong ideological, if not partisan valences. The more that the Supreme Court can do to disincentivize that kind of behavior by litigants and by lower courts, I think the more the court can do to sort of take pressure off itself and to reduce the incidence of these high-profile, culture war-heavy lawsuits that really do, I think, not paint the court in its best light.
Of course, you wrote the book Shadow Docket, which I recommend. And when you started writing the book, the court really had a lot of cases that were brought before it where it exercised the shadow docket, and then it was beginning to decline. Is the shadow docket the same thing as these emergency orders that are coming in?
I mean, so it's not a technical term. It's a term that was made up by a University of Chicago law professor named Will Bode, and I sort of shamelessly appropriated it from Will. I think, Jim, the shadow docket, as Will and I have used the term, is actually meant to cover everything that the Supreme Court does away from the high-profile, 60 or 70-page opinions that we get in the cases that are argued. So if we think of the 60 or so some odd rulings that the Supreme Court hands down every spring with lengthy decisions after multiple rounds of briefing and argument, we think of that as the merits docket. The shadow docket is basically everything else. And, emergency applications, these requests from parties to adjust the status quo while cases are working their way to the merits docket, are just one part of the shadow docket, Jim. I mean, another big part is, the way that parties even ask the Supreme Court to take up appeals in the first place. What are called petitions for writs of certiorari, or cert petitions. But the emergency docket, as some folks call it, has become a real flashpoint over the last 7 or 8 years, because more than ever before, we're seeing efforts by governors, by presidents, by private actors to get the Supreme Court to weigh in long before the case has worked its way all the way through the courts, and to try to get the Supreme Court to, adjust the status quo in their favor, whether that means blocking a federal policy, unblocking a state policy. We're seeing more and more of that in the context in which we've already seen a bunch during the second Trump administration.
Well, that was one of the issues that Justice Alito used in his dissent, that it had not worked its way through the lower courts.
That's right. And, I think part of what is to some degree frustrating about trying to make all of these, Jim, often very technical rulings accessible to non-lawyers is that there are very few absolutes when it comes to the Supreme Court's procedures. There are a bunch of norms, and the norms prefer that cases work their way through the lower courts. The norms prefer that the court only weigh in once an issue has fully, in the court's word, percolated. But just about all of the rules, Jim, are actually written so that there can be exceptional cases and there can be extraordinary circumstances in which the Supreme Court is allowed to, and indeed does, step in at an early stage of litigation, provide relief at an early stage in litigation. And Jim, one of the things that we've really seen in recent years is no matter your politics, folks can find examples of emergency interventions by the Supreme Court that they like and emergency interventions that they don't like. And the common theme, I think, is that the Supreme Court is just not at its best in these contexts because you're getting rushed decision making, you're getting often no or very little explanation, and you're getting the justices really sort of stepping out of their normal process in some context, Jim, where they're nevertheless deciding pretty weighty statutory or constitutional questions. And so, the point here is not that this is about one ideology over the other. It's that this has been a pretty fundamental shift in what the Supreme Court does on a day-to-day basis that I think in the long term is bad for everybody.
So how many justices have to agree when a case is brought in an emergency action?
So the procedure here, again, is a little weird because the court is not actually public about a lot of this. A typical emergency application goes to one justice. It goes to whoever is the designated circuit justice for that specific geographic part of the country. And so, the case you mentioned about the Alien Enemy Act, where the Supreme Court weighed in late in the evening on Good Friday, that was a case that came out of Texas. So the circuit justice was Justice Alito. And Jim, the norm, right, is that the circuit justice acts by themselves. The majority of applications are either granted or denied by the circuit justice acting individually. Jim, many of those are anodyne and they don't get a lot of attention. The headline generating ones are usually referred by the circuit justice to the full court, where it takes 5 votes. So 5 justices are required to grant relief. Which is a pretty big difference from what's true for how many votes it takes to take up an appeal. Usually it takes 4 votes to grant certiorari, to take up plenary review of a case on the merits docket. You need 1 more, right, if you want to upset the status quo while all that process goes forward.
So what would have happened if Justice Alito had said, no, we're not going to look at this? Could the ACLU have gone to another justice?
So the rules do technically allow for emergency applications to be filed with a second justice. And then, Jim, the norm is that the second justice refers the application to the full court. I will say, since 1973, which is the only really visible historical example of this happening, there are no known instances in which the full court overrode the circuit justice. Right? That the norm really has been that the circuit justice is ruling not as he or she might wish to, but as he or she expects the full court to rule. And so, I think the circuit justices have a pretty good track record, Jim, of being right about that, of, either handling things by themselves when they were absolutely sure no one was going to disagree, or if there was any doubt at all, referring the matter to the full court and letting the full court decide.
So as I was driving to the studio this morning, I thought about this, that typically the term for the Supreme Court each year is October through June. Given the number of cases and anticipated cases in Trump 2.0, could the Supreme Court extend its term, or how will they convene when they are teaching at various European law schools?
Yeah, I mean, it's a good question. So again, here, I think we have to distinguish between what the rules say and what the norms are. So since 1980, the Supreme Court has had a rule that it actually remains in session, at least legally, all the way up until the next term starts. And so, it is absolutely normal in the discourse to say, oh, the term ends when the justices finish handing down, the merits rulings from the term. So late June, early July. Legally, that's not true. Legally, the term actually keeps going all the way until the next term starts, the first Monday in October. What that means, Jim, right? And you hit the nail on the head, is that the court is increasingly busier over the summer than the justices are used to being. They're getting more, high-profile emergency applications that can't wait. They're getting more, late-breaking cases with ticking clocks that can't wait. And so, we've already seen, as we're recording this, the court has already added one argument for May 15th in the birthright citizenship cases. I don't think they're done, Jim. I think we're probably going to have at least one or two more very, very late arguments this term. And, that's relevant, Jim, I think in two respects. One, it underscores just how much what's happening at the Supreme Court today is abnormal compared to the court's historical procedures. But two, the justices historically really use the summer as a reset, as a recharge, as a way of sort of, getting out of the building and getting away from each other for 2 months after what are often some of the most contentious fights they'll have in the highest profile merits cases of the term. The more that this is just a constant for the court, the more that they are locked into this perpetual state of emergency, I think the more deleterious that's going to be for how well the justices get along with each other, for how much trust and respect there is in the building among, the sort of different camps. And the more, Jim, it normalizes procedural behaviors by the court that are meant to be used only in emergencies. I mean, the more, if everything's an emergency, you get to a point where nothing's really an emergency.
And as you and others have written, like Jeff Toobin, about the decorum of the court, even though they may have really knockdown, drag-out fights, when they get into their chambers, they actually try to get along.
That's right. I mean, these are 9 people who are going to be together for the rest of their careers. And, for as strong as I think we all feel about the court, I think we've also all been in professional settings where we understand the importance of getting along even with our colleagues who maybe we don't agree with.
Said as a true professor.
Faculty politics might be a good example of this. But I mean, I don't think, Jim, we talk enough when we talk about the Supreme Court about the significance of these kinds of interpersonal politics and, office politics. I mean, it was, the Ginsburg-Scalia friendship, for example, which is often much maligned by folks who, point out that neither really seemed to influence the other. I actually think it was valuable, not because either sort of moved toward the other ideologically, but because it fostered a healthy respect for views with which you disagree. And it fostered an ability for the justices to sort of talk to each other, even if not especially when they were at loggerheads substantively, versus just sniping at each other, not trusting each other, scheming behind each other's backs. None of that is healthy, no matter what the end result of those internal dynamics are.
And to date, it's rarely happened. So a criticism of coming from the Trump administration is the power that district judges have to put in place national injunctions. We've seen so much of this. Where do you stand on this? Because it does seem like a district judge has an inordinate amount of power.
So federal district judges absolutely have an inordinate amount of power. Jim, that's been true since at least the beginning of the 20th century. And, one of the things that Congress did back in 1910 is to take a bunch of cases where Congress was worried about how much power individual federal judges had and require them to be brought before so-called 3-judge district courts. So special courts that actually had 3 judges where you weren't as at risk of drawing, say, the most extreme judge in the district and having that decide the case. Congress over time relaxed that so that by 1976, 3-judge district courts were basically gone, except in a small handful of cases. Maybe Congress should bring those back. But Jim, what I'm struck by in the arguments against nationwide injunctions is that these aren't, for the most part, with only a couple of exceptions, arguments about like real deep principles. And what do I mean by that? So if your opposition to nationwide injunctions is that you don't think federal courts should be able to bind non-parties, which is what the usual sort of argument is, then presumably you'd be totally okay with reinvigorating a nationwide class action, with allowing a group of plaintiffs to sue on behalf of everyone in the country who looks like them or who's in the same relative boat as them legally. And yet the same folks, Jim, who are criticizing nationwide injunctions have shown no interest in, putting teeth back into class actions after the Supreme Court, in a series of decisions in the early 2010s, made those much harder to bring. That's the concern I have. Like, I totally understand the critiques of nationwide injunctions, but it seems to me that if the point is just that particular vehicle is problematic, you can fix that. If the point is that we don't want the courts to be able to check the executive branch at all in this way, that's a much bigger claim, and it's one that I think would be a lot harder for a lot of folks to take seriously, given the critical role that the courts play in our checks and balances. Now, I think, Jim, more than ever, when we're seeing less and less of a role by Congress in trying to hold the other branches accountable.
Yeah, I think that's absolutely true. I mean, you really do not have the three branches of government operating equally. And Congress has abdicated a lot of its responsibility.
And that matters, Jim, because, just take immigration policy for a second. There's obviously going to be an enormous range of views about what our immigration policy is and ought to be. And that's as it should be in a pluralistic democracy. Congress hasn't passed meaningful, substantive immigration reform since 1986. And so the result has been that presidents of both parties have been left to set immigration priorities by executive order, where folks who are opposed to that particular president's approach can then go challenge those executive orders in court on the ground that the president doesn't have the statutory powers to take the steps he wants to take. And so what you have is you have a dramatic increase in the frequency and the seriousness of confrontations between the executive and the courts, because Congress has not stepped in to fill the gap with modernized, updated, substantive legislation. Again, Jim, folks are going to disagree about whose immigration policies they like and whose immigration policies they don't like. What I think can't be denied is that when you're leaving presidents of either party to fill in the vacuum, the result is, one, they're going to fill it, but two, Jim, the way they fill it is going to be more legally vulnerable. And it's going to be more legally vulnerable in ways that just wouldn't be true if Congress did its job.
So we have just about two and a half minutes left, and no interview, no article right now doesn't end or pose the question, is there a constitutional crisis? And what does that mean today? And I think as a follow-up question, has President Trump's administration defied the Supreme Court as of this point?
So I'll take the first question first because it's easier. I don't love the term constitutional crisis, Jim, because I don't know what it is. And more to the point, I don't know what it means that we're in one versus not in one. I think there's no question at all that we are in a separation of powers crisis, that we're seeing a president arrogate legislative power and control over appropriations, control over spending, control over law firms, control over everything to a degree that we've never seen before. And that gets back to the theme of congressional fecklessness. The crisis of sort of constitutional dimensions really is your second question, which is Trump ignoring the courts, and is he ignoring the Supreme Court? And I guess, this could change quickly because things move quickly and we're only 3 months in, hard though that may be to believe, to the administration. From where I sit, Jim, I view the administration as trying very hard to find every iota of plausible wiggle room in every single judicial decision that's out there. Trying to sort of walk a very fine line between not overtly defying the courts, but also not trying that hard to comply. And, my sense is that's because the administration wants to be able to say, for example, to congressional Republicans, oh, no, we're not defying the courts. We're just, we're just reading their mandates narrowly. that may, Jim, produce the same result on the ground. And it may look to a lot of folks like there's a lot of non-compliance. From a sort of pure separation of powers perspective, the virtue in that to me is that we have not yet reached a point where President Trump and his advisors are saying, we are not bound to do what the Supreme Court has told us to do. Right? We might misdescribe what the Supreme Court has told us to do, but there's been no suggestion that the Supreme Court says X and we're doing not X. Maybe we're heading in that direction, but I think it says a lot about where we are that we haven't gotten there yet.
Last question, what's the biggest misunderstanding that we as citizens have about the court?
That's a great question. I think the biggest and most pervasive misunderstanding is the notion that like judicial independence is an end unto itself, that we have independent courts because independent courts are a sort of an unalloyed good. That may sound like nerdy, but I think it's really important, right? We have independent courts because, to borrow a quote from the late Professor Paul Freund, we don't want judges and justices to be sensitive to the weather of the day, but we do want them to be appreciative, to be reacting to be aware of the climate of the era. And that's the question. How do you strike that balance between having courts that are independent, but not so independent, Jim, that they lose the ability to rule in the cases we want them to rule in, and to lose the ability to bind us when we need them to bind us?
That's a great way to conclude, and also want to remind everybody, One First is just a terrific Substack piece. Again, Steve, thanks so much for being with us. It's really been a helpful conversation. And if the early months of the Trump administration are any indication, we can expect an unusually high number of legal challenges in opposition to the president's agenda. And while the conventional wisdom has been that the executive branch will respect decisions taken by the judiciary, many of the actions taken by the 47th president have been unprecedented, testing the very guardrails so carefully designed by our founders. Time will tell us just how bumpy the ride may be. Thank you for watching, where we talk about things that matter with people who care.